Hello and welcome back to another episode of The End Game. I'm Melissa Butterworth and I am your host of the End Game podcast. Today we have such an exciting guest. I am just so thrilled to have Emily Johnson with us today. Not only is she like a powerhouse woman, but I consider her to be a friend and colleague who I've worked with on a number of transactions over the course of a number of years. And I am just so excited to have her. And before I turn it over to Emily to let her do an introduction of herself and her background, I always like to share a fun fact about our guest. And today I'm going to share a couple of fun facts. First of all, I learned many years ago that if you're going to travel with Emily, you better be prepared to get up bright and early because she's usually going to find the local Orange Theory gym. And you're going to be headed to the gym first thing in the morning, which I love that about you, Emily. I think it's awesome. And it kind of goes with the other fun fact, in the fact that I learned that every New Year's Eve, like we, all come up with our own New Year's resolutions, except for most people's New Year's resolutions are like, I'm going to lose weight this year. Well, Emily, no, Emily's New Year's resolutions are, let's see how many sweets I can eat this year. And I guess that goes hand in hand with why you're in Orange Theory every day. You're fabulous. Not only are you brilliant, you're a beautiful, beautiful woman. And, but I just love those fun facts about you. And again, it's such a pleasure to be here with you today, Emily. And I'd love you to give our audience a brief introduction of yourself and your background.
Sure. And thank you so much, Melissa, for having me here today. I think this is fabulous. I've been looking forward to doing this. So thanks again. And with respect to my fun facts, I wouldn't say that one serves the other. I've always been like a fitness fanatic, so that's why I like Orange Theory, and I'm super competitive, and I like that it gives me that release. With respect to the New Year's resolutions, on the other hand, I like to set goals that I can accomplish, and who doesn't want to eat more desserts? Or one year it was to drink bourbon, and I'm not much of a golfer, so for business development, I thought maybe I'll learn about all the bourbon so I can bring that to the table. So, it's strategic. There's reasons for these things. I'm not just a Looney Tune. But my background, so I'm a healthcare regulatory partner at McDonald Hopkins. We are a Cleveland-based law firm, but I am out of the Chicago office. I have been practicing law since 2010, exclusively in the healthcare field, always representing healthcare providers or health systems. I started my career with the National Association of Boards of Pharmacy, then switched to a healthcare consulting group. And from there, since I think, 2015, I've been with McDonald Hopkins. We are a full service firm, and we do everything from healthcare regulatory to the transactions that we work on with you, real estate, tax, white collar, bankruptcy, litigation, estates and trusts, really, you name it, we do it, with the exception of criminal law. And so I have the pleasure of working with Melissa and her team often. It's amazing to work with you on these transactions. My day-to-day work involves primarily representing labs and pathology groups on day-to-day compliance work. But I certainly work with a wide variety of healthcare providers, not in just those industries. But the day-to-day compliance issues can be billing issues, Medicare issues, strategic contracting with potential business opportunities, Stark-Banana kickback compliance, of course, ACRA in the lab space. And then I do, like I said, a fair amount of transactional work. I'm not an M&A lawyer, but I do support our transactional team on deals. We do a lot of sell-side deals and more buy-side deals. But my role on a deal is to serve as the healthcare regulatory point of contact to vet the diligence issues that might come up to make sure that the transaction works under the applicable healthcare regulatory framework. The last hat that I wear is privacy. So I do a fair amount of data privacy work at the firm. I don't do a tremendous amount of data breach work anymore, but I handle all of the investigations with the Office for Civil Rights when our clients are investigated. And then I do also provide a lot of proactive privacy compliance advice. So that is me in a nutshell.
Wow. That is so impressive. You really are not only yourself, but I have to say, like, all of the folks that I work with at McDonald Hopkins are top notch. I whenever we're going through a transaction and a client says that they're using McDonald Hopkins, I am so happy to hear that, because you all are just, a wealth of knowledge, of course, in many different areas. And, not only that, but I think what I love about it is that each one of you independently really complement each other as a whole, as a team, and you actually get the transactions over the finish line, which is amazing. So I love that. And we've got such an exciting topic today. I know that a lot of our audience is really going to be interested in this. Our topic for today's episode is going to be recent regulatory and enforcement actions that are impacting not only laboratories, but also pathology groups across the country. And I know that this has been a really hot topic, and I know that our viewers are going to learn a lot in today's episodes. And I guess the best way to kick off today, Emily, would be, high level, what are some of the recent enforcement trends that you are seeing?
Yeah. So in the lab space, I think it's more of the same, right? Labs are sort of, unfortunately, the low-hanging fruit from the federal government's perspective. And so they're routinely scrutinized and sort of held to a different standard, or so it feels, than some other healthcare providers. We are still seeing significant scrutiny of toxicology tests and panels associated with ordering toxicology testing. And then the other area of testing that's seeing a lot of scrutiny right now is genetic testing. There's a lot of piggyback arrangements with genetic testing. The reimbursement is sort of uncertain. And so we are seeing, we'll call them creative reimbursement arrangements, where specimens are received in one location, but maybe then shipped to another location so that labs can take advantage of friendlier payment jurisdictions. And so a lot of those arrangements are being highly scrutinized, sort of rightfully so, from the government's perspective and a payer's perspective, because there are strict rules regarding when and how tests can be billed, and you need to be mindful of those rules. Failure to comply with the billing rules results in recoupment and potentially civil and criminal investigations, and nobody wants to go through that. But we see a ton of those. So that's with labs. People bring up ECRA all the time. We're not seeing a ton of ECRA enforcement. There certainly are cases out there, but I think for the most part, people have a good handle on what they should and should not be doing under ECRA right now, at least until hopefully ECRA changes at some point. With respect to pathology groups, actually, there's been a lot of buzz lately. I'm not sure if you're familiar, but in September, the OIG issued an advisory opinion on TCPC arrangements, technical component and professional component arrangements, where, one portion of the services are being purchased and sold. And oftentimes these arrangements are entered into between like a specialty provider, like a dermatology group or urology group, and a pathology group. And the rationale for entering into these arrangements is usually one of those parties. It's typically I'm going to pick on GI groups. It's typically the GI group who can't bill for those services. And so they'll perform a component, and then the pathology group will pay the urology group or GI group to perform that component, and then the pathology group will bill globally. The government has always scrutinized these sort of purchase services arrangements. And what was interesting about the advisory opinion in September was, in that arrangement, the parties acknowledged that the arrangement was fair market value. So the payment for the services that was being made was fair market value, but the government said, we don't really care about that. It's not commercially reasonable. But for the fact that this resulted in referrals going to one group in exchange for paying the other group, this arrangement wouldn't be entered into. And they focused on the fact that the pathology group is more qualified to actually perform both components of the test. And so the fact that they were entering into this arrangement really didn't make sense. Now, you and I know that there's tons of these arrangements out there, and I don't want to say the majority, but many pathology groups have these types of arrangements, right? And I think it was sort of a cautionary tale of, we know what the government says about these, but if it's fair market value, we should be okay. Not the case anymore. And we are seeing enforcement by the government in this regard. So we have a lot of pathology groups who are in the process of converting those arrangements to end the purchase services arrangement and make sure that each party that's performing services is billing for the services that they perform. This
Wow.
has not been without significant strife and headache on our clients' part, but you see what the government is doing. We have this guidance from the government, and although the OIG advisory opinions aren't necessarily binding, right? It's guidance. You have an understanding of how the government is going to approach these arrangements. And so we do get that question a lot from clients. They're like, do we really have to convert these arrangements? Because this isn't actually a mandate by the government. And the
Right.
response is always, well, no, it's not a mandate, but do you want to face the scrutiny that the government is going to give you if you continue or enter into one of these arrangements? And from my perspective, the answer is no, right? Why would you take that risk?
Wow, that's unbelievable. It's shocking. I mean, I can remember back in the days when I was in business development and actually was out selling those types of
Right.
arrangements,
Yeah.
and so it's unbelievable because it's a lot of those arrangements are put together, for the benefit of the
Right.
patients, right? And it's shocking to me to see all of these changes and the government gets so involved, but it's I guess it's good to be well advised, and that's what you can help the clients with. I mean, what would you recommend? What is the best way from your perspective, McDonald Hopkins perspective, to help labs and pathology groups avoid potential,
Yeah.
investigations?
So the immediate thing that comes to mind is having a compliance plan in place, right? So a compliance plan is going to have identified folks within the organization who are going to be responsible for staying on top of compliance and monitoring compliance. And that includes training. So, I mean, I'm sure you've seen this when you were working out in the field. Your biggest weakness sometimes or vulnerability are what folks are selling. And so, if they're selling a problematic arrangement, it sets up your entity for compliance issues. So, regular training of sales teams and key decision makers to make sure that any arrangement that they're entering into meets the requirements of the law is going to be really, really important. Not everybody has in-house counsel to vet these arrangements, but certainly new arrangements should be reviewed by key decision makers at the organization. And if possible, outside counsel, right? I don't want to plug lawyers here, but it really is important to have qualified healthcare counsel look at these arrangements. It's totally different to have a complicated healthcare arrangement reviewed by, say, a real estate attorney or even a corporate attorney, right? They don't know the nuances of arrangements that might seem like they make good business sense, but they don't work under the healthcare framework. And so having those checks and balances in place are really, really important. Like I said, regular training of your personnel is really, really important. And then periodic audits. You can do ride-alongs with your sales team to make sure that they're doing things compliantly. And we talk about this all the time in the transactional space, billing and coding audits, because you might be getting reimbursement, and just because a payer pays now doesn't mean you're not subject to recoupment later. And so making sure in doing those audits to confirm things are being billed and coded correctly so that you can have comfort in knowing that the reimbursement you're getting is truly going to be yours and not subject to any type of future clawback.
Yeah, no, that's a great point, Emily. And I do want to touch on what you said about, making sure that, whether you're a pathology group or your laboratory, that you do have, a good legal firm that you're using. I mean, I have to say this. I mean, if you are a patient and you've got heart issues, you're not going to go to a general, you're not going to go to a general practitioner. You're going to go to a cardiologist. I always say that because it's so important that you, in my opinion, that you use lab specific healthcare, which you all certainly have the expertise in that. And I think that's really critical, especially when you're dealing with these types of things. I mean, what should lab owners do and or pathology groups do if they have been sent notification that they are being investigated?
Yeah. So at that point, before you respond, so if you receive, whether it's from a commercial payer or from the government, if you receive any type of notice of an audit or an investigation, it's really important to get legal counsel involved at that point. The last thing you want to do is just respond to a records request or respond to a civil investigative demand without running it by counsel who knows how to respond to these things. The first thing that we do when our clients get a subpoena or civil investigative demand is pick up the phone and call the prosecutor, or whomever the attorney for the government is, or if it's a payer issue, contact the payer and find out, are we actually the subject, and in the government sense, are we the subject of this investigation, or are we just an interested party or related party or a party from whom they can get information to further their investigation of somebody else? That really is critical in how you want to frame your response. You're still going to have to provide the documents that are requested, but you want to be careful in what you produce and not overproduce, and also not produce anything that's been already subject to attorney-client privilege, right? So similar to like what you said, getting experts involved, you want to make sure all of this stuff is reviewed prior to sending anything to the government. And then we have, document teams that we work with who can help with like the automated processing of pulling documents and using, the e-discovery search terms, which are great. And it makes it much easier for the client. For payers, my reimbursement colleagues would tell you, and I already said it about reimbursement, if you get paid, it doesn't mean it's not subject to clawback. They would tell you, even if you get a medical records request, even if it doesn't seem like something significant, it's still best to run it past either a billing and coding person or an attorney. And the reason for that is payers tend to extrapolate issues. And so what may seem to be a fairly innocuous request for information could be extrapolated into a bigger investigation if they perceive there to be something wrong with the records that you submitted. And so it is always in your best interest to slow down, take a deep breath, and figure out who you need on your team to best represent your company in those situations.
Yeah, no, that's really, really great advice. I mean, I'm curious from your perspective, if a lab or a pathology group has received notification that they're under an investigation, what is your perspective or advice on whether or not this is going to impact their ability to go to market if they're looking to potentially sell?
So I think, like with respect to a government investigation, that's where knowing whether you're the target or not of the investigation is going to be really important. If you're not the target of the investigation and you have proof that you're not the target, that can be extremely helpful in going to market, right? It's still going to be something that comes up in diligence, but for purposes of what's going to impact the valuation of the company, perhaps that has a lesser impact than if you are the target of an investigation, right? Because you can say, yes, we had this arrangement, we weren't party to it necessarily, we have information, but we are going to cooperate, but it shouldn't impact the value of our business. If you are actually the target of the investigation, it's much different. Certainly not a prohibition on going to market, but as you know, it's going to impact the value of the business, right? It might not impact directly the purchase price, but it would impact anything that might need to be held back in escrow and what the time period for that is. And unfortunately, government investigations move quite slow, way slower than an M&A deal does. And so it might mean holding back a significant portion of the purchase price in escrow until resolution of the investigation. And certainly selling your company does not get you out of an investigation. So we get that question too. Just because you sell doesn't mean the investigation doesn't continue.
No, absolutely. Absolutely. I saw a recent transaction that was about 2 weeks away from closing when they got a notification of investigation, and it blew the transaction up because the buyer was looking to do a stock transaction and they certainly didn't want to assume those liabilities. So it's all a very good point. What other types of issues, arise during due diligence that may be specifically related to regulatory issues?
That's a good question. So it can be anything. So starting with our lab deals, it's ordering, right? What does the ordering process look like? What do your requisition forms look like? How are you paying your sales reps? Are you complying with ECRA? I said that we're not seeing a ton of enforcement in ECRA, but it certainly can impact compliance and disclosures in a transaction. The other thing that we see come up a lot is earnouts. the transactional team might want to pay an earnout. And in our pathology deals, we see this, right? They want to pay an earnout, but it includes special stains. Now, generally, pathologists aren't generators of referrals with the exception of special stains, right? That is considered a referral. And so if you're going to pay an earnout, whether it's a pathology deal, a lab deal, a cardiology deal, you have to carve the designated health services under the Stark law or DHS out of the earnout calculation. If you don't, you've got some pretty significant Stark exposure there. Another thing that comes up, I mean, we see this on some cardiology deals, some radiology deals, is there are certain requirements, certain disclosures that need to be made to patients at the time services are made under the Stark law. And if you don't make those disclosures, they're technical violations of the Stark law, which, is ultimately going to end up in some sort of payment for whatever that self-disclosure is. The other things that come up are really, typical things like kickback issues, paying referral sources. Now we're going to see a lot of this TCPC stuff in pathology deals. What are you doing with your purchase services arrangements, and why are you entering into these, and what justifies it? And then in the digital pathology space, we see a lot of, we'll call them creative digital pathology arrangements that might not meet the requirements of the Stark law or the anti-kickback statute as far as how the services flow, who's paying whom for what services, who's submitting claims for reimbursement. And so we have seen certain digital pathology arrangements blow up transactions like you were talking about, because there was just too much risk and too much revenue tied to this particular aspect of the business.
Yeah, and those are very good points. So how can lab owners and pathology practices be proactive and, prepare for due diligence so that, these items, don't come up, and or if they do, you can get through them much quicker?
Yeah, it's a great question. And I wish more of our clients would ask this question before going to market. It's really about doing the compliance audits that I had previously mentioned. It's much better to know the skeletons in your closet before somebody else finds them. And by doing so, you have an opportunity to cure whatever risks or mitigate whatever risks were found before it can potentially impact the valuation. You and I have seen this 100 times. Nothing slows down a deal faster than a regulatory issue that comes up that all of a sudden maybe we need to get a state agency involved, or we have a disclosure that needs to be made to the federal government. Preparing in advance to make sure you have all of your policies and procedures reviewed, all of your training material available, everything that you would want, sort of like selling your house, right? You're going to clean every room in your house and you're going to organize everything so that your house looks the best it can look when people come to look at it, when it goes on the market. Same thing with your business. People aren't going to maybe come in and see it the way a house would, or sometimes they do, but you want to have all of your ducks in a row in advance of going to market if you can. I understand it's not always feasible, but if you're routinely doing these things before you go to market, then you should have much more comfort in knowing what your weaknesses and vulnerabilities are going to be. The last thing you want to do is be in the middle of a deal, have something come up, and then have the parties get back on the phone and say, we need to reassess the purchase price here because this issue was found. Nothing causes deal fatigue like that question or that conversation.
No, you're absolutely correct about that. Wow, we've covered a lot of really great, valuable information today, Emily. For our viewers and folks that are just tuning in, if they want to get in touch with you and they want to learn a little bit more about some of the things that you do at McDonald Hopkins, what's the best way for our viewers to reach out to you?
Yeah, you can email me at any time. My email address is ejohnson@mcdonaldhopkins.com, or you can certainly call our offices, or my direct line is 312-642-1798. But whatever's easiest, happy to answer any questions people might have, or just get on a call and talk about how you can assess your own compliance to mitigate some of these issues in the future.
Yeah, no, I'm very, very appreciative. A lot of wonderful, wonderful information. I learned a lot today, and I'm certainly certain that our viewers did as well. And if you would like to see today's podcast again, Feel free to go to Apple or Spotify, as well as www.advancedstrategicpartners.com. Thank you for tuning in, and I look forward to seeing you again in 2 weeks on our next episode of The End Game.
Thank you so much.